Good morning. Welcome to the Supreme Court of the United Kingdom. This morning we're handing down the judgment in the matter of the Queen on the application of KBR Incorporated and the Director of the Serious Fraud Office. Under the Criminal Justice Act 1987, the Director of the Serious Fraud Office, the SFO, has powers which it can use to investigate suspected cases of serious or complex fraud. These include the power set out in Section 2, subsection 3, to issue a notice requiring persons to produce documents and other information for the purposes of an SFO investigation. Failure to comply with a notice of this kind is a criminal offence. The issue raised in this appeal is whether the SFO can use the power in Section 2, subsection 3 to compel a foreign company to produce documents it holds outside the United Kingdom. In other words, does the power in Section 2, subsection 3 have extraterritorial effect? The Respondent invited this Court to proceed on the basis of the factual position at the date of the Divisional Court hearing on the 17th of April 2018, and we agree to do so. The Appellant, KBR Incorporated, is a company incorporated in the USA. It does not have a fixed place of business in the United Kingdom, and it has never carried on business here. However, KBR Incorporated is the parent of a multinational group of companies which includes UK subsidiaries. One of those subsidiaries, Kellogg Brown Root Ltd, or KBR UK, was under investigation by the SFO. On the 4th of April 2017, the SFO issued a notice under Section 2, subsection 3. This notice was addressed to KBR UK and required it to produce certain information and documents. KBR UK provided various documents to the SFO in response, but explained that certain material was not in its possession or control. It told the SFO that if and to the extent that this material exists, it was held by KBR Incorporated in the United States. On the 25th of July 2017, officers of KBR Incorporated attended a meeting with the SFO in London. At that meeting, the SFO asked KBR Incorporated if it would provide the outstanding material required under the notice it had issued to KBR UK. When KBR Incorporated told the SFO it would need time to consider this, the SFO handed the Executive Vice President of KBR Incorporated a further notice under Section 2, subsection 3. This second notice, the July notice, required KBR Incorporated to produce material it holds outside the United Kingdom. KBR Incorporated applied for judicial review to quash the July notice. Amongst other things, it argued that the notice was invalid because Section 2, subsection 3 of the 1987 Act does not permit the SFO to compel a company incorporated in the United States to produce documents it holds outside the United Kingdom. KBR Incorporated's application failed at first instance. The Divisional Court held that Section 2, subsection 3 extended extraterritorially, provided there was a sufficient connection between the relevant company and the United Kingdom. On the facts, it found that there was a sufficient connection between KBR Incorporated and the United Kingdom, so the SFO's July notice was valid. KBR Incorporated appealed to the Supreme Court. The Supreme Court allows the appeal. When construing Section 2, subsection 3 of the 1987 Act, the starting point is the presumption that UK legislation is not generally intended to have extraterritorial effect. This presumption against extraterritorial effect is rooted in the requirements of international law and the concept of comity, which is founded on mutual respect between states. Whether Parliament intended Section 2, subsection 3 of the 1987 Act to displace the presumption depends on the wording, purpose, and context of the legislation, considered in light of relevant principles of international law and comity. Beginning with the wording of the legislation, the SFO draws attention to the breadth of the words used in Section 2, subsection 3, which confers a power that can be exercised against the person under investigation by the SFO or any other person, and can relate to the production of any specified documents, provided they are relevant to an investigation. However, when Parliament intends legislation to have extraterritorial effect, it often makes express provision to that effect in the statute. There is no such express wording in Section 2, subsection 3. The wording of the other provisions of the 1987 Act, similarly, has not shed any light on whether or not Parliament intended Section 2, subsection 3 to have extraterritorial effect. A submission on behalf of the SFO which found favour before the Divisional Court was that Section 2, subsection 3 must have at least some extraterritorial application, because the SFO could use it to compel a UK company to produce documents held, for example, on an overseas server. However, the Supreme Court finds that this does not cast any light on whether the legislation can be used against a non-UK company, such as KBR Inc, in the very different circumstances of the present case. It therefore becomes necessary to consider the purpose and context of the legislation. The SFO submits that the extraterritorial effect of Section 2, subsection 3 must be implied. Otherwise, the purpose of the legislation, to facilitate the investigation of serious or complex fraud, which often has an international dimension, could not be effectually achieved. The difficulty with this purposive reading of the statute is that it is not supported by the legislative history of the 1987 Act. The relevant provisions of the Act were enacted to give effect to the recommendations in the 1986 report of the Fraud Trials Committee chaired by Lord Roskill. That report and the subsequent parliamentary debates on the resulting draft legislation indicate that Parliament's intention was that evidence of fraud should be obtained from abroad by establishing reciprocal arrangements for cooperation with other states. This is also supported by more recent legislation. Since 1987, successive Acts of Parliament have developed the structures in domestic law which permit the United Kingdom to participate in systems of mutual legal assistance between states to facilitate criminal investigations and proceedings. These systems of mutual legal assistance are subject to protections and safeguards, including provisions which regulate how documentary evidence from overseas may be used and make provision for its return. These provisions are fundamental to the mutual respect between countries on which the system is founded. It is unlikely that Parliament would have intended them to operate alongside a broad unilateral power which permits the SFO to compel foreign companies to produce documents held outside the United Kingdom under threat of criminal sanction and without the protection of any safeguards. Both KBR Incorporated and the SFO referred the court to previous judicial decisions on the extraterritorial effect of other statutory provisions. These decisions should be approached with caution because they concern entirely different statutory schemes, which were often enacted for different purposes and operating in different contexts. That said, the reasoning of the Supreme Court in Serious Organised Crime Agency against Perry is instructive by way of analogy, because there are close similarities between the relevant statutory provisions. The SFO relied on a number of other judicial decisions, many of which involve powers under the Insolvency Act 1986. However, since these powers are not sufficiently similar to the power under Section 2, subsection 3 of the 1987 Act, the Court is unable to derive any assistance from them. In its decision, the Divisional Court found that the SFO could use the power in Section 2, subsection 3 to require foreign companies to produce documents held outside the United Kingdom if there was a sufficient connection between the company and the United Kingdom. This sufficient connection test is not supported by the language, context, and purpose of Section 2, subsection 3, so there is no basis for its implication. Reading a sufficient connection test into the legislation is inconsistent with the intention of Parliament and would involve illegitimately rewriting the statute. For these reasons, the Supreme Court unanimously allows the appeal of KBR Incorporated and finds that the Section 2, subsection 3 notice issued to KBR Incorporated is invalid. The Court is now adjourned.